I'm happy to see Mr. Ogada, who is my brother in human rights and legal learning. Thanks also for Mr. Kadima and the entire Avid Readers fraternity for starting us off. As it's already been said, Katiba is turning 15 in a short while, 27th August. And we at Kabarak are already doing exciting things as we prepare for that moment. Already, faculty and mostly students have already done research on all the articles of the Bill of Rights, the 40 articles, and we are at the editorial level with the hope that we'll be able to publish a book celebrating 15 years of Katiba, starting with the Bill of Rights, and then we'll go to all the other chapters. The idea there is to look at how far we've come from the beginning to today. Have we, advanced forward? Have we gone sideways or back and forth? And stuff like that. I think we'll be able to do that analysis. Those chapters will be presented as part of the conference that we will have on 25th, 26th, and 27th of August to celebrate 15 years of Katiba. What makes me very excited is that the Avid Readers begins to take us there through a number of webinars that they have organized. And the Avid Readers is part of Ask Kabarak, but it's always good to tell them thank you when they do great things like that. And so this one marks the beginning of that conversation of reflecting on human rights and Katiba. For some reason that I think must be good, this webinar also coincide with the real day of Maandamano today. And I think it will be good, even as we speak, to have in mind that a lot of us lost lives last year, a date like this, and since then a number of abductions that we can't even explain, and people are missing, including today, who we are not in a position to account for. Not even state authorities have been able to account for that. That conversation, I hope, will be part of the discussion that we have today. Just a note, because I'm not a panelist today, just a note of something to think about, especially as a father of a 15-year-old myself, a Katiba age mate in the house. I've always looked at my son every time discussions on Katiba have arisen, and every time I'm asking myself, how far is the human being turning 15 on August 27th? How far have they come? Okay, and there are many things I think to expect. I think most of you would know that that's the group that actually is doing CBC, Pioneer CBC. They're the first ones now selecting senior school. They've been in junior school, and next year they're going to senior school. And it's interesting to see how at individual level they are battling also national challenges that have constitutional value as well. For example, a problematic curriculum that keeps being changed or modified here and there. And that is also the same story of Katiba. But Katiba is more at global or national level, going through the struggles of a nation. As a father, I can report that bringing a child up is an iterative process. Long ago I thought that you tell a child, please do not play with water in the kitchen because you can fall and get injured. I used to think that they would take the instruction right away. In reality, that's not what happens. It's actually repetitive. You keep repeating. It's still going back to the same trend, and then you keep changing and changing. Oh, it's June in Nairobi, for example. You need to have a sweater, especially in the afternoons, in the evenings, or warm clothing. You have to repeat that every day. And perhaps, just throwing the spanners into this works even at the beginning of the conversation, perhaps that's where we are. When we inaugurated Katiba in the year 2010, I was a very happy person. I believed that Katiba was going to be a boundary, going to be a line, marking an old order that we are going to shun, and a new and progressive path that we are going to follow a bit more constantly and much more regularly. In reality, what I found to be the case is that that is not obvious. Our leaders, our institutions, our people will require the same iterative process of a 15-year-old, repetitive, pushing vigilance, correction, and sometimes what we are doing today, mandamano, or even um, a bit of muscle from the people to get the government or our institutions in the right path. So my suggestion as I finish is that we must keep the vigilance going. We must keep the discussion going. We must keep the critique going. And I believe that is what avid readers are doing through this forum. I wish all of us, therefore, on that note, success as we reflect on Katiba in the area of civil and political rights. I wish our panelists success, and I'm also looking forward to a great discussion going forward. Asanteni sana, and God bless you all. Thank you.
Thank you so much, Professor John Osompambani. And now, ladies and gentlemen, it is my great honor to introduce our panelist today, who is a legal mind and stands at the intersection of constitutional litigation, human rights advocacy, and public service, Mr. Evans Ogada.
Have the capacity, the right to speak, the right to express ourselves. Those who are brought in to capacitate us, to give us emancipation when wielded against certain forces, rulers, for example, the church, these stood out as power statements. Now, 17th and 18th century first generation formulation bring in an evolution in terms of constitutional law. Constitutional law is thought of differently after the theorization around first generation right. And you find a good number of constitutions reflecting this new ideological shift. So that the constitution after the 17th and 18th century is both prescriptive and procedural. What do I mean by prescriptive? Prescriptive constitutions or parts of the constitution declare certain values, okay? And these values are shared values that bound the state, bound the society, that nobody was required to depart from them. Rulers, the governors were not required to depart from this prescriptive value. Then we had the procedural capacity of the Constitution, or the procedural aspect of the Constitution. The procedural part provide structures for governance. They announce institutions that allow for us to implement governance. So they are like pathways. So we have the prescriptive values, procedural, institutional. Now, why did I give that story? The Bill of Rights in Kenya today is both procedural and prescriptive. Procedural in the sense that it declares certain normative institutional frameworks that we need to adhere to. Prescriptive in the sense that it announces certain norms, certain values. The entirety of, for example, our chapter 4, Article 19 to Article 59, those 40 articles, it's in and of itself, the entirety of it is prescriptive. It announces a value. The procedures, Article 49, on how to conduct arrest, Article 50, the rights of those who have been detained and trial, and the trial process. These are procedural institutional normatives that govern, for example, the trial phase. So the Bill of Rights is both prescriptive and procedural, and that is a legacy of the 17th and 18th century, aimed at, number one, giving capacity to the individual, and number two, stopping rulers from encroaching into certain spheres. Thank you, Ruth.
Thank you so much, Mr. Evans Ogada, for your preliminary statements. It has indeed been a good background and of where first generation rights came from, and even particularly in the context of Kenya. So I'll now proceed to ask you the specific guiding questions. And the first question relates to the judiciary, which I think is a topic that you have engaged widely on. So the first question will be, how have Kenyan courts interpreted and enforced first generation rights? I remember last year, the Honorable Justice Lawrence Mugabe determined a decision that related to the right to picket to demonstrate by stating that the KDF deployment on the Gen Z protests was actually constitutional. So how have they interpreted and enforced these rights, cutting across not only this right, but other first generation rights? And do you think that there is discernible trend in judicial activism or restraint on the same?
Well, I think the judiciary checks a mixed bag in terms of the treatment of first generation rights. The premier years of the Constitution 2010, that is the Mativo, Ngugi, Lenaola court, we saw some flicker of hope whereby you could predict going to court that the court could reason in a certain way. We have since seen some backsliding in terms of certain decisions. I always point out to the Security Amendment Laws decision. That one was horrible. I don't brook qualms about it. I have always raised my concerns with. I've raised my concerns with decisions on bail and bond, for example, where you find decisions touching on bail and bond being determined in ways that can at best be astonishing. What is the problem with adjudication in terms of rights? It is not disciplined. That is one. Because, for example, if you look at our Article 33, which talks of war truth, it talks of the freedom of expression. That is what our Article 33 speaks to. I have yet to see the court grapple with the title. The title to a constitutional article is called a chapeau. I have yet to see why any court interrogate why we have our Article 33 titled as freedom of expression as opposed to freedom of speech. Freedom of expression is much broader, and it has nuanced reasoning why it is titled as such. Then if you look at 33, for example, 33 has what we call foundational elements at 33.1. These are elements that you cannot take away from the essential content of 33. Then we have certain vices that you will not claim when speaking of 33. And those are captured in 33.2. For historical reasons, propaganda for war, incitement to violence, hate speech, these are precluded from the benefit somebody can gain in 33. I am yet to see, and 33.2, in terms of constitutional law, Ruth, is called an internal qualifier. And we have enough rights within the Bill of Rights that have what we call internal qualifiers. So before you jump into the poetry I see in some of these judgments, running to all manner of cases and reasoning from Uganda, I usually get surprised when we quote cases from Uganda, Nigeria, and these other illiberal democracies. Look at your constitution. What does it say? Okay? And then, when you don't find your answer by the plain textual reading of 33 as it is, then you move to 24. Ruth, for those of you who are conducting your assignments, Article 24, and I know Professor Mbani has taught you this, Article 24 is a verbatim from the celebrated case of the state versus Makonyane, 1995, the first decision of the South African Constitutional Court. That tiered or layered method of bridging a right came from a reasoned process. It brought in tests of rationality, proportionality, and the like. When you see what comes from our courts when dealing with Article 24, you will be pleasantly surprised. Because Article 24 is dealt with as if it's a statement of English expression, as if you will read English aid or these books in English lessons from our ordinary bookshops. No. Article 24 is an announcement of value. A constitutional article is nuanced in itself. So that you read the Bill of Rights in its totality, the 40 articles, as a principal declaration in and of itself. Then you read the exceptions to enjoyment of rights internally within the article, or look at Article 24. That kind of reasoning I don't see in many of our decisions. And perhaps that informs the chaos we have with, for example, bail and bond, whereby somebody is arrested, presented to court, and then you hear a court grant 14 days for somebody to be detained while investigation is happening. That is against the Constitution. So, for example, when you detain somebody beyond what is permitted by the Constitution, what comes about for us in terms of Article 29? Article 29 talks of freedom and security of person. What does freedom and security of person normatively mean? How can you limit Article 29, freedom and security of person? I'm sorry, I'm venting. You've given me the opportunity today. Let me speak my truth. Let's go to the death penalty decisions by the court. There's a case that I openly wrote about. This is the case of Njuguna versus the Republic, whereby the court dedicated, I think, 1 or 2 paragraphs to say that the death penalty is constitutional. Without going to the dignity questions, the cruel and inhuman degrading treatment questions, the question that I always ask these courts, as a penal consequence, does the Constitution allow you to extinguish a right or to limit a right? It allows you to limit a right, not to extinguish a right. So can you give the state the authority to take out a life as a penal consequence? That has not featured, rationalized, and reasoned from our courts. So the judiciary needs to pull up its socks. We cannot reason and give reasons that do not pass muster, are not well articulated, and we expect to stem the chaos. And that informs the impunity and the arrogance you see with the police service, whereby people think that they can arrest you, come to your house without a warrant, and then when you go to court, you're told, it's enough, just go claim damages, that will suffice for you. The Constitution is prescriptive. The Constitution has procedural normative positions. We cannot continue reasoning with the Constitution as such.
Thank you so much. So that actually brings me to my next question about state power and rights and retrenchment. As you've talked about the rights to a fair trial and rights of arrested persons, what do you think about the implications of this state-backed abductions and enforced disappearance on the right to security and due process? And to also go to the question that I'm pretty sure a lot of people here are thinking, the implications of the failure of this current regime to address intolerance, or rather to allow intolerance and in a way be unable to allow for dissent in their own regime. So do you think these practices, of course, as you've mentioned, they do not align with Kenya's obligations, but do you think they align with under the Constitution, but do you think that how do they violate international human rights law? And Are there any other recourse for Kenyans beyond judicial remedies, as you've said? Unfortunately, the mode of interpretation as of now does not align to the spirit or the purpose of the Constitution.
Again, I am glad that Professor Mbani told me you are reading and you're researching. I want to send you back to books again. Let's continue reading and researching. I want to send those who are reading to Weimar, Germany. This is about 1930 or thereabout. The Weimar Republic is ushered in as a rebirth of the state after the vagaries of First World War. They have a very good constitution, a constitution that had a Bill of Rights, checks and balances, everything that you'll want to look at in a constitution. That constitution did not do more than 5 years for the reasons that, number one, it was undermined by politicians, whereby politicians think that their interest and what they think supersedes the constitution. Number two, we have laws that were deliberately left intact to undermine the constitution. We also had unofficial acts of state, powers of arrest, arbitrariness, that clouded and made nonsense of the constitution. And the Yashpal guy, Okoth Ogendo, Constitutions Without Constitutionalism, have explained this better. That is a similar scenario we see in Kenya today. So you see, for example, if you look at your 6th schedule, those who are reading and researching, we have section 7 to the 6th schedule. That, in terms of constitutional law, is what we call an ex ante repeal clause. Ruth, you are looking at me asking, what is this guy saying? Is he speaking in Latin? No. An ex ante repeal clause means this, that all laws that existed before the Constitution 2010 should be read and dealt with in the tenor and spirit and the demands of the Constitution 2010. So that, for example, when you're dealing with the Evidence Act, the Civil Procedure Act, those old laws, the secrecy, the Oaths and Secrecy Act, the Government Records Act, those old laws, you have to read them in light of the realities and spirit of the new Constitution. It also means that by virtue of Section 7, Schedule 6, that the normative values of the Constitution should preponderate how we think about the Constitution. What do I mean? That when you are dealing with, for example, and you mentioned human rights is mentioned at Article 10 as a value and or principle. What does that mean? A value and or principle is foundational. It informs all else. And the Constitution is elaborate enough in Article 10, for example, to state that everything that we do, including policy, must be informed by these national values and principles. Have we been doing that? No. Because when we say that human rights, and human rights has an identifiable core that we can work with, should inform how we do things, then we cannot be tolerating Ojwang being taken from Homa Bay, being executed in a cell, and then we go through the official rigors to cover up. We cannot have killers sitting in parliament and making law today in the name of we need to go through the appellate process and finish it in line with the reasoning in the international policy case. We are killing the Constitution. We are hemorrhaging the Constitution. We are making the Constitution be as redundant as how it was in the Weimar Republic. And politicians will always not want to be limited by the Constitution. The politicians are always happy about the layering of institutions, the power aspects of the Constitution. The office of the president, this is what the office will say. those aspects they will like. But where they are told that there is a duty for you to do A, B, C, D, you are stopped from doing A, B, C, D. Politicians, including myself, if I was in that position, it will be difficult for me to conform. And that is why, and I send you again to constitutional theory, we have a Greek story called the Ulysses story of this captain of a ship who was sailing and had to request that he be bound to a mast so that when he hears nice sounding music, Ruth, I don't know what you dance to, but some people from where I come from dance to something called Ohangla. Where Professor Ambani comes from, it's called Isikuti. That temptation that will make you to dance to Isikuti or Ohangla, Ulysses said, no, bind me to a mast, so that when that music plays, I will be restricted. I will not be allured to the music. I will be confined to this mast. That analogy, I always remind my audience that reflects what we meant and intend with the Constitution. That our temptations, our weaknesses as human beings need to be bound by a constitution, the prescriptive, the procedural aspects, the rules, the principles, so that we are not tempted to deviate and become the feral animals that we all are. Because without those rules, without those bound restrictions by the constitution and left to our own elements, we will become the Hobbesian state where people do what they want. I hope you answered, Ruth.
Yes, 100%. And speaking of Mr. Ojwang, may his soul rest in peace. What do you think? How do you think the state has handled the regulation of online speech and also the limitation freedom of the media in consideration of their constitutional obligations and Article 33 and Article 34 of the Constitution? Do you think that the way that the state has handled it is causing a chilling effect? And additionally, what role do you think digital platforms and these media stations play in expanding or constraining the civic spaces? Yeah.
I think that media has fairly tried. Of late, we've seen them suffer a lot of challenges, including reduced income, reduced capacity. They have their own challenges, but they are trying in very difficult circumstances. We have to applaud the rise in social media because social media has filled the gap, the void that mainstream media has not been able to deal with. So social media has been largely a tool for positivity, whereby citizen journalists are able to inform us productively. I'm not speaking about these ones who insult and say things that are ethically not right, but those who use social media responsibly. Be it as it may, freedom of expression, access to information, freedom of media, freedom of expression, these are intertwined. So that, for example, and I saw the commission authority, the director general, purporting to issue instructions today for media not to have air coverage. May I use this platform to remind him of the law? Because I'm an officer of the court. What he did was arbitrary, null and void, and without legal consequence. We have a decision by the Honorable Justice Chacha Mwita, which declared such acts unconstitutional. So you cannot purport to tell media not to air certain things that are uncomfortable for you and embarrassing to you. Because I have within my possession that when that was ordered, certain persons in motorbikes started moving around the city, clobbering protesters. So the question will be asked, what was the intention of the CA Director General when he ordered the stopping of live broadcasts. So for us as citizens, we need to remember that power yields nothing without a demand. We have to keep at it, keep eternal vigilance, and continue asking questions. Our traditional allies in this quest has been civil society, has been the judiciary. If we didn't have just the justices madam of this world, Justice Onguto, Justice Mativo, those good judges who understand the assignment and made bold declarative decisions, we would claw back. And we risk democratic backsliding if we continue having horrible judgments from the court, and if we continue having these archaic and stupid laws from parliament, because the new entrant, the new kid on the block, is the so-called Computer Misuse Act, which has some very gray areas, very loose textured areas that have been used to arrest and intimidate, particularly young people. So you post something that some head honcho somewhere does not like, you're arrested, and you're told you have misused your computer. That was what Ojwang was arrested for, and eventually murdered. So we need to keep vigilant, because if we don't keep vigilant, there are a number of tactics that will be used. The state and the totality of state includes the constitutional commissions, the Kenya Human Rights Commission, which is being starved of funding today, the Ombudsman's office, all these office, the Gender Commission, because when people threaten to stab women in the street for purposes of political agenda, that's a gender question. I don't know why the National Gender and Equality Commission has not spoken to this. We need to keep vigilant.
I agree.
Yes.
Completely. And I appreciate that you've mentioned non-state actors who are contributing to the realization of this civil and political rights. But what do you think about the legal education and scholarship? Where does it fit in shaping these rights, especially with regards to enhancing its discourse? I note that the Avid Leaders Forum is one of them, but how can we use it to ensure that these rights are observed, protected, promoted, respected?
Education in its broad sense is a very important tool. It capacitates, it emancipates. So through legal education, the awareness improves, the advocacy skills improve, and we become ambassadors for the essence of first generation rights. So legal education must continue, and we need to bring in better tools in terms of legal education. We suffer in this country capacity in terms of certain research tools, in terms of legal education. You will find that we are disenfranchised in terms of access, particularly for perhaps the public universities, whereby the libraries still reflect the 1970s and 80s. ICT capacity in terms of e-resources are wanting. Those are handicaps in terms of the achievement and the evangelization of the normative importance of first generation rights. So we cannot emphasize any better that legal education is important to nourish the future of law in this country, because Ruth, our predecessors, the late Firoz Norji, my good friend, our elders, Mheshimiwa Mwite, Mheshimiwa Manyara, Martha Karua, Judith Ongori, the late, they blazed the trail for us. They did what they could do with this constitution. Let this constitution, and you called it one of the most progressive constitutions in the world, 264 articles. fairly well written, it will not go down the fate of the Weimar Constitution because my generation, your generation, let it go down. For us to keep it alive, we need to ensure, number one, that we increase capacity. Number two, we continue learning and never at any moment think that you have achieved or you are there. I'm Miss and so, I'm Miss Ruth Jebet. I am now an expert in constitutional law. No, my teacher, Justice William Musyoka, and the late Professor O.K. Mutungi always reminded me that every day when you wake up, ensure that you learn something new. So my challenge to all of us is when you wake up each day, if the sun sets and you have learned nothing new in terms of constitutional law and in terms of socioeconomic rights, I mean, in terms of rights generally, first generation rights, consider that day wasted. Thank you.
Wow, thank you for the challenge. Definitely encourage the audience to practice it and encourage myself to practice it. And allow me to just veer into a right that is there, but the question is it the law as it is or is it as it should be? And that is Article 27 on the right to equality and non-discrimination. We have seen a lot of jurisprudential developments around, for example, the affirmative action and substantive equality. For example, the two-thirds gender rule before the legislative body, the parliament. Yeah, but we don't see this provision being implemented to ensure that it aligns with Article 27. We have the Crew 1 case, the Crew 2 case, and so many other follow-ups, the cases that was brought up by the judiciary, but we still do not see Article 27 and the attendant provisions that are meant to implement this being followed and being instituted. So what could the problem be? And how do you think we can be able to move from a lex ferenda situation to a situation where the law is what it is? Yeah.
Again, it boils down to our first sin, the reading and interpretation of the Constitution. So Jabet, and I know my good friend Professor Ambani is an innovative thinker. He's a refreshed thinker, and he's exposed you to new dynamics and new reasonings around the Constitution. You cannot deal with the Constitution 2010 when referring me to the Golden Rule, the Mischief Rule. Which other one did we study? Those old yellow notes that we study. Those rules have been overtaken by events. You certainly cannot use common law norms to read and interpret the Constitution. Again, I'm throwing it to you. There is Professor Philip Petit. He has written on interpretation of the Constitution. He has about 6 methods of reading the Constitution. Our Constitution has at least, bare minimum, 2 major theoretical premises for interpreting it. If you look at 259.1, it announces what we call the purposive reading of the Constitution. If you look at 259.3, it talks of the living tree reading of the Constitution. The living tree reading of the Constitution was first dealt with in a 1930 case, Edward versus Canada. Lord Justice Sankey in that matter, explaining the elements of a living tree reading of the Constitution. What have we been doing here? The Supreme Court attempted to give us an answer in the case of Jasbir Singh Rai and 3 others. This is a 2012 case, and I will encourage us to read paragraph 89 of that. Professor Justice Willie Mutunga, Chief Justice Mutunga, who is now at Kabarak, you may have a conversation with him. He got it right when he explained what is meant by a transformative constitution. A transformative constitution is bold and is correctional. It intends to touch every sphere that is social, economic, and political. we have not gone the full breadth of the Constitution in terms of Article 27. In terms of gender parity and gender questions, we have been circumventing and going around it. I remember there's a team where my former dean and friend, Professor Mbote, and others had even formulated a formula to deal with the gender question. I think Parliament sat on it. There's a decision that declared Parliament unconstitutional and illegal on the basis of its gender composition. Persons, for purposes of political expediency, have failed to act on it. Let's go to persons who are with disability, persons traditionally marginalized. Look at Article, is it 54 on persons marginalized? How have we developed jurisprudence around that area? And that's on the court side. There's a duty and obligation of the state in terms of even our international obligations as per various treaties that we've signed on to. We are far off. If you look at CEDAW, look at what the monitoring committee has said in terms of Kenya's capacity to help women. It has been wanting. And you see, we're still struggling with challenges. We're still struggling with challenges such as femicide. So we are far off, and it's a cocktail of problems. We have judicial challenges there. We have political challenges. We have resource challenges. And of course, sheer willpower. We have not deliberately set out to do things the right way.
I agree. And maybe just to go to the regional platform, what do you think about the African Court on Human and People's Rights and the United Nations Human Rights Committee as a body that mans the implementation of civil and political rights? How have they influenced Kenya's rights landscape?
Well, those bodies have, in their small way, tried. And for example, with the African Court, we have the Ogiek case that was rendered by that court. The Human Rights Committee, and indeed other human rights-oriented offices and institutions within the UN, they rendered their reports. However, for us as Kenya, our toxic culture of bad manners continues to be a handicap in terms of realization of what has been declared and decreed by these international and regional courts and offices. So let's go to the Ogiek case, for example. We have a judgment there that spoke to the Ogiek question. What do we do here? We failed to abide by that court decision, and it forced Katiba Institute to go to court to compel the government to abide by a court order. Hello? Are we together?
Yeah.
Yes. So Katiba is forced to go to court to force the government to just respect court orders. We remember what happened with the ICC cases. Politics and institutional interference with witnesses and muddying the whole thing. Again, denying victims of justice. So Kenya has a toxic culture of bad manners that creates parallel reality to what the Constitution and the law says. So unless and until we just try behaving properly, nothing will get moving in this country. Is it Mwalimu Ongoya who always reminds me that you cannot legislate good manners. Good manners is ingrained in you. you have to behave properly as an internal capacity. We need to remember that.
I agree. And indeed, Mr. Ngoya emphasizes that all you have to do as a country is just stop, having bad manners. And
Yes.
maybe in that light, maybe do you have examples of countries that have good manners, particularly that have comparative models that Kenya should emulate? I know you've given examples of the failed constitution in Germany, but yeah.
Well, examples are there, and let's not pretend that countries are perfect. No, but we have examples of people trying in their own spheres to just do things correctly. So, for example, we have an item of constitutionalism that we have not nurtured well in this country called constitutional conventions. The political enforcement of constitutionalism, whereby when you are caught or engaged in a miasma of ethical infraction, you step aside for the reason of the glory and honor of public office. So you move away and leave the office clean, its integrity intact, rather than doing it the Kenyan usual way of I'd rather die than resign. We have just basic manners in terms of how we deal with each other. Ubuntu, Utu. A country that is nurtured and instructed on Utu and Ubuntu, you will not murder Ojuang and then take us through charades of legal mundane processes so that we get certain people off the hook. You will go for the culprit. You will go for those arresting officers. You will go for those officers we saw at some hospital, ask them hard questions. They produce who was coordinating the whole effort around Ojuang. And that person will be prosecuted in the normal manner as a capacity of the rule of law. Nobody is above the law. It's a capacity of Utu. But in this country, it's about who has the most money, including looted and stolen, who knows who speaks what language. Somehow, if somebody comes from my rural village in Nyahera and speaks my father's native, the Luo, that person is super gold and has to be protected at all costs. Stupidity of the highest order in the year 2025. We need to behave properly.
I agree. And we will just give you a chance to maybe give your closing remarks on that. And then as you give your closing remarks on the last question, I will just urge everybody, to anyone who has a question, to note them down on the Q&A box. And if you want to ask, you can also raise your hand. If you want to verbally ask it, you can also raise your hand, and then we'll figure out a way which can allow you to speak. Yes.
So you have a final question, or you want me to make concluding remarks?
Concluding remarks.
Okay. I am first and foremost a lawyer, and I believe that Kenya's salvation lies with an ethical, disciplined, productive judiciary. And one of the tools that the judiciary has under the Constitution is constitutional review. It must be remembered that constitutional review creates a stock of capital that the designers of the Constitution sought to draw on to resolve impasses in our political system, in our social sphere, in our economics. So, for example, I will want to challenge you to look at Article 225. Why is it that by constitutional decree, the National Treasury is created under Article 25 as a special office? What does that mean in terms of the functions and the capacity of that office? That's a constitutional question that we are yet to grapple with. So constitutional review and constitutional law generally represents a higher law, which all other laws and government action must comply. By engaging in constitutional review, I beseech the judiciary to enforce the hierarchy of constitutional law. Constitutional review must speak and remain a mechanism that enables for the preservation and the implementation of the Constitution. It is a means for us to give force to constitutional provisions and to prevent the acts that violate them. If we don't do that, we are going to suffer what has been called the Weimar syndrome. This constitution will die, this constitution will be buried, no matter how normative, no matter how progressive it is. Thank you.
Thank you so much. And now this concludes the first part of our webinar session, which is our conversation and a question and answer session with the panelists. And I'll just usher in the next section, which is the Q&A session. And therefore, if you have a question, kindly raise your hand just raise your hand, indicate, or ask a question in the Q&A session.
No questions always means a good thing, that the class has understood. Eh?
Yes.
Okay.
And maybe we can then discuss. I know what is going on right now, that is the freedom of the right to assemble, picket, and demonstrate, and maybe discuss the trend of the current state in managing this particular right. Do you think it reflects the philosophy of this current regime, because it's a practice that has carried on now for another year? Or do you think it's does it go to the root, and does it exemplify a mode of a culture of the continent's form of not stomaching dissent, as we said, or not stomaching intolerance? Since when you go to other nearby countries, you will find that they are considering this form of the ability to picket, assemble, demonstrate, to actually be an extensive form of freedom compared to what they have. But as we noted, our constitution is among the most progressive, but that has been the pattern in this particular regime. So and then I will carry on to ask the questions in the Q&A box.
With regards to those rights, allow me to remind us of first principles. And those first principles will be found in Article 19, Article 20, Article 21, and 22 as well. So if you read the totality of those articles, you will find certain consequential elements. The first is that the state does not create the rights we enjoy, that the rights we enjoy have a certain normative core, that the rights we enjoy are subject only to the limitations in this constitution. Any limitation to a right has to be in law, amongst other elements you will deduct from here. What we have witnessed of late, this habit of kidnapping, the habit of extraordinary renditioning, citizens, all these bad habits that we have seen since 2022 only point to what I call democratic backsliding. What does that mean for this country? It means we are going to lose investments. People are not going to come and invest in a country that is always on the TV and it appears burning. A while back, somebody called me. We are supposed to be having United Nations offices moving into Nairobi by the year 2026. And some of the concerns these UN officials have is our tolerance with LGBTQ matters. And I am told that some people within the UN circles are actively objecting to those offices coming into Kenya. They are also concerned about our civic space, civil and political rights, because they see videos and images of people being killed and shot in the streets. That's another concern. So we may suffer the consequence of these offices going elsewhere. And I am aware that Paris and Kigali, Rwanda, are actively lobbying to shelter some of these offices. So we may lose economically. In terms of image, the image of the country is suffering. You go out there and you are always this country that is associated with violence and with regression. You will be losing a lot in terms of prestige and honor. For a long time, and during President Moi's regime, he had his many problems. But at least Kenya was respected as a diplomatic station. That no longer avails because of the bad manners that we see of late, where rebels from certain countries come in and move out of this country despite having international crimes hovering over them. We see Kenya being mentioned adversely in all manner of aspects. We are embarrassing the republic. And the state does not belong to politicians. The state is ours. This government is an agent of the state. So we need to call ourselves to order that if we continue in this manner, we will no longer have a country to call home. We will lose comparatively and in terms of advantages to our regional neighbors and to other countries.
I agree. And it is indeed a delicate balance between, on one hand, wanting to have a country that, respects constitutional rights and ensures that the dignity of its citizens is maintained. And on the other hand, ensuring that we also have, as you've said, a country that we can go back to. And it's a very difficult time for the country. So I will just continue with the questions that have been asked on the chat box. I see Tito has asked, but there's an anonymous attendee above him. So let me start with the anonymous attendee. They've asked about constitutional review. How should we address the fact that the executive interferes? I'm guessing the process of constitutional review, interference by the executive. And then the second question, kindly elaborate on the theories of interpreting the constitution to the extent that they are inapplicable to Kenya's constitution. Is it your considered opinion that we should discard the common law interpretation theory completely, or should we revisit the applicable theories? So his question
Only
goes
those
to
two?
interpretation. Yes, so far.
Those two?
Yeah.
Let me go to the first one. Interference with the courts. And interference with the courts are myriad. In the last budget cycle, and indeed in the last 2 or 3 budget cycles, it's been a long series of happenings. You have noticed that the judiciary has been seeing a shrink in terms of the available for it to profitably perform. That is deliberate. It is ensured that the judiciary will be limping. And that is despite the fact that the Constitution announced the creation of the Judicial Fund. The Judiciary Fund should have been up and operating And the conversation should only be happening within the judiciary, the National Treasury at Article 225, and Parliament. The weak link has been the National Treasury, whereby politicians and people who operate as politicians have been, for example, handicapping the judiciary in terms of resources. Parliament has also failed in its obligation to ensure that the judiciary is capacitated in terms of how it needs to work. So that's one area of interfering. We also know that the judiciary needs to pull up its socks in terms of accountability and in terms of how it conducts itself. The judiciary and its main currency is public perception. If the judiciary intends for its mandate, for its authority to resonate with the public, it must conduct itself properly. The judiciary must maintain public support, because that's the only line for you to protect yourself against the excesses of the political branches. So the judiciary must stem the rot in itself. And the rot in itself starts with corruption. Let's not lie. We have a problem with corruption, the judiciary. Let's tackle that. The officers that misconduct themselves within your ranks, ensure that those grievances are tackled. Because if you don't enjoy the support of the public, you are not going to have supporters to help you when you have these third-rate politicians going after you. Because politicians have what I call pea brains. Their minds revolve around 5-year election cycles, and they look at things short-term. The judiciary is structurally intended to think long-term, to think of the health of the state. And that is why in the year 2025, we still think of modern Chief Justice. Long after C.J. Mutunga left, when the noise has settled, we are looking at some of the things he wrote, and we are saying, this guy had some idea. He had the future and the country at heart when he was writing this. That is why we think of Justice Onguto long after he's gone. We are looking at Justice Mativo. We are looking at Justice Nyakundi, Justice Odunga. That needs to continue. It needs to be sustained, because if we drop the ball, this country is going to sink. The theories of constitutional interpretation. To the brother or sister who asked that question, I want you to look at Article 3, not 3, sorry, the Supremacy Clause, Article 2, and particularly Sub-Article 4. Article 2, Sub-Article 4 ensures that all those canons, all those rules of common law that we used to cut and paste and patch in cases have nothing in terms of significance. The Constitution ascribes or prescribes to normative value positions, so that when you want to interpret this Constitution, you start with the values that it stands for, because the values and principles go on top, and that should preponderate all else. In terms of constitutional interpretation theories, this can be a whole class. But for purposes of reiteration, I want us to look at 259.1. And I said that 259.1 has been argued to articulate what we call purposive interpretation of the Constitution. Purposiveness of the Constitution, or the purposive method of interpretation, has about 4 elements. I have seen certain decisions that deal with purposivism as if it's an English phrase in a dictionary, makosa. It has 4 conceptual elements that need to be defined. I'll want to send us to Professor Aaron Barak and French philosopher Robert Alexi, who have written extensively on purposivism. Is it Mangebeiro? Mangebeiro also has written on purposivism. Look at what those authors say on purposivism and ask yourself, what we say in our decisions, is that purposivism or a clone of it? It's a problem. You look at 259.3, the living tree reading of the Constitution. I think Justice Mutunga got it spot on in one of the decisions he penned, and that probably owes to his Canadian school background. Professor Mutunga studied in some school in Canada. So he gets it with the living tree reading. And I told you the living tree reading of the Constitution is of Canadian origin. So you look at the case of Edward versus Canada, 1930, Lord Justice Sankey. What was intended to be achieved with a living tree reading? The Constitution is speaking. What does that mean? We need to ask ourselves that question afresh. And then, of course, we have a patchwork of borrowed items in the Constitution. We have the proportionality test that you'll find in Article 24. That is of German origin, the Constitutional Court in Germany. What was intended to be achieved with the proportionality test? So it's not enough to quote verbatim R versus Big Mat. Read the conceptual origin, the reason, the rise on depth of this concept. Then when you understand the rise on death, you go to case law. But for us, we are quick to rush to case law, including some ridiculous cases from Uganda and Nigeria, and then call that judicial decisions that should nurture this constitution. It's a problem. In the Bible, we are told that old wine, new wine cannot fit in old wineskins. When you take decisions from illiberal settings and fit them in this new into this new wineskin, it will burst. The Constitution must be read in its full tenor. It must be read in terms of its normative importance. I hope I answered the questions.
Yes, and your teaching professorship side is really showing. I feel like I'm in an intriguing constitutional law class. So the next questions will be first from Christine. She asks, kindly or requests, kindly clarify on the syndrome you talked about during your closing state remarks, the death of constitutions, if I had that correct. And maybe I just read the second one, which is, the judiciary has been praised for defending civil and political rights, but its rulings often face resistance from the executive and legislature. Does this reveal a fundamental flaw in the Constitution's design, where checks and balances are undermined by political impunity? The Constitution allows for the limitation of rights under specific circumstances, such as national security. Is this clause unnecessary, safeguard, or a dangerous loophole that enables the state to suppress rights with impunity? So these questions are, I believe that now not just one question, they're complex of questions, a multiple of questions. So yeah.
Okay, what we call the Weimar syndrome. The Weimar syndrome is named for the Weimar Constitution. Weimar is WEIMAR. The Weimar syndrome is a term we use in constitutionalism to refer to the deliberate undermining of the Constitution by a cross number of methods. And I will invite you to read the history of the Weimar Constitution. Progressive, contained a Bill of Rights, checks and balances, everything you will want in a constitution. But just exactly as was then, we see today in Kenya, whereby there are certain problems that continue to undermine the potency of the Constitution. And I started off by saying that I have a problem with the reading, and I referred you to Philip Petit. He writes quite well in terms of constitutional reading methods. We have historical, textual, doctrinal, which other one? Structural. We have a myriad ways of reading the Constitution, so that you will not read the Constitution as if you will read an English textbook or the dictionary. That's not how to read a Constitution. You cannot use English dictionaries as a general rule to define terms in a Constitution. That's a problem. So when you use those combination of methods, you significantly gnaw away from the potency of the Constitution. Of course, we have the political tactics, and we have spoken extensively about them. Consistently, these contribute to what the late Okoth Ogendo spoke about in terms of constitutions without constitutionalism, whereby you have a beautifully written transformative constitution, as we call this one, but it's just a mere piece of paper. The constitutionalism part, the restrained part of the constitution is missing. The constitution declares that the authority of the judiciary, including the orders it gives, must be respected. Somebody sitting in Harambee House, office of the president, thinks that they are too big. 6, 7 orders are issued against acting IJ Master Ngeli, and it becomes normal. When we go to court, all manner of excuses are found to excuse Master Ngeli because he's a big person. In other countries, we have had ministers simply resign for coming into parliament late for 5 minutes. We have the example of Edwards in the US, the darling of the Democratic Party, who was found with his girlfriend on the side when his wife was sick. And he had to resign from the Senate and quit politics because of just that infraction. Here in Kenya, we have a politician who was convicted of murder, representing you in parliament. We have people who have cases with the EACC sitting in parliament, convicted killers, representing you. We are killing the Constitution. The second question, which was a compound. The judiciary needs to up the game, especially with constitutional adjudication. It's an untidy morass. It is underwhelming. It raises concerns. And somebody had said before that Justice Mugambi decreed that military deployment proceeds. I am involved in that one. The final judgment is not yet out. But what he refused to grant was conservatory orders to stop the deployment. And he gave his reasons, which some of us disagree with. Because the test for conservatory orders is articulated in Gatirao Munya. In my personal opinion, the lines of demarcation between national defense and national security are well demarcated within the Constitution. The involvement of the military in civilian roles is mediated under Article 58 under clear parameters. The court ought to have considered that. So we need to take things seriously. If you're going to excuse things under the altar of political expediency and allow these politicians to reign roost and do whatever they want, the Constitution will suffer. In terms of judicial review, we need capacity. If it were my wish, we will have a specialized constitution. Because if you look at the achievements of the South African Constitutional Court, for example. You have judges there for 9, 12 years. They get out, they go into academia. And during their tour of duty, you look at what Mogoro, Keito Regan, Digang Moseneke, Pius Langa, those good judges. I mean, it's intellectually nourishing to read from these judges. I'm an unapologetic admirer of Moseneke. You read what he writes, you may not agree with him, but you will be thoroughly amazed by what he writes. We need to get there. In terms of the politicians, the court has the tools in terms of the constitution to rein in the bad manners in terms of politicians. We also as lawyers must play our part in terms of elevating the discourse in courts. So don't get, you find lawyers going to court and citing civil procedure rules in court, not looking at the constitutional principles and the Mutunga rules. What do they mean? We need to also do our part as lawyers, as scholars, as teachers to elevate the discourse. We have good capacity in this country. Let us stop being lazy. Thank you.
Thank you so much. And I'll just read out the last question. And an anonymous attendee asks, it seems as though our salvation lies in an ethical, proactive judiciary, taking into account the fact that the judiciary itself is pervaded by various problems such as corruption and lack of capacity. Who has the responsibility of ridding the judiciary of its internal rot so that it can save the constitution and the nation in turn? Also, should the common person just sit and wait for the judiciary to put its house in order and save us rather than storm the streets?
Vigilance. We need to remain vigilant. We need to remain accountable. We need to act properly. The call to be an advocate, the call to be a lawyer is a higher call. And that is why in my classes where I teach, I always remind my audience that don't come into law thinking that you have come into any other business. This is not your mama mboga kiosk. This is not your kiosk where you go and buy and sell uchi. This is an office that carries with it great responsibility and great demands. Think of this responsibility as that of a pastor or a bishop or a cleric, an imam. The responsibility that comes with it are heavy. So that how you conduct yourself and how you deal with matters bears not only for your own image, but the image of others. We cannot continue dealing with things in such a perfunctory manner, because the first line of defense for this country at the moment is the judiciary. The judiciary can only play that role when we do things correctly in terms of reading and interpreting the law. We stop these habits of some 5,000, some 2,000 for some orders and case briefs. Corruption has to be dealt with from within. And we cannot continue this way. The country will tank. The millions that you're holding will not help you when this country burns. And we saw that last year when the country was at the brink of collapse. Nobody could have been saved. We will have all burned here. It takes great courage and responsibility. The kind of ethical spine that Justice Madden and others have exemplified, Firoz Norji has exemplified for us to do things correctly. That I will never tire from repeating.
Wow. Thank you so much. And I note that you have given your closing statement, but maybe I'll just give you 2 minutes to reiterate something that you want to reiterate, or maybe vouch for something that you want to vouch for, and then I'll introduce our convener. Yes.
Read or perish. That is for you, the younger generation. This country is boundlessly rich with enormous potential. We are operating below capacity. It's a tragedy that we are yet to achieve the greatness this country can attain just because we are not doing things right. And especially for us in the legal sphere, the challenge is for us to take things higher. We can't be struggling with jurisprudence and still not getting it. Mwalimu Elisha Ongoya is training to teach you jurisprudence that you're getting nothing out of. When in other countries, people are studying arithmetics combined with jurisprudence in the name of a study subject called jurismetrics. That's where the rest of the world is. The rest of the world is thinking of AI and the law. Where are we as a country? We're still thinking of 2,000, 5,000 bribes to get orders. We need to shape up or else we will lag behind. That's my parting shot.
Amazing. Thank you so much. You have provided such deep reflections and insights on our conversation today. And I think with your experience in constitutional litigation and scholarly works that you have done, you have reminded us that rights is not just the implementation of these rights is not just about looking at what the Constitution says, but implementing it with the intended spirit inside the courtroom and outside the courtroom. So thank you so much. And I think with voices like yours, we can be able to really implement and realize the promise of the Katiba at 15. Yes. And now it's my absolute honor to welcome the thought leader of We Must End Bad Manners, our convener, Mr. Elisha Ongoya. Really happy to have you. And yes, kindly, you're welcome.
Ruth, please confirm that you can hear me.
Yes, I can hear you.
Thank you so much. I am not a speaker or presenter today. I have been a listener and I have learned a lot about the VIMA constitution and the bad manners that annihilated it. The second thing I have learned this evening is Mr. Ogada's assumption that students don't ask questions because they have understood everything. Mr. Ogada, it may as well mean that they have understood nothing and therefore they don't know where to start from in asking the question. But having said that, allow me to begin by thanking the New Look Avid Readers Forum under the stewardship of Mr. Cedric Kadima, who have put up this show. This has been an absolutely phenomenal show. I have followed this conversation, and I think it's a worthy way of celebrating our 15th anniversary of the Constitution of Kenya 2010. I am certainly very grateful to Mr. Gada. We would not have had a better speaker to take us off in terms of this celebration. And from where I sit, I know that this is just by the beginning of a great menu of intellectual conversations that we are going to benefit from as young students. A week ago, and just reflecting on today's theme, I shared a file image of Reverend Dr. Timothy Njoya being clobbered at Parliament buildings. And I know because that happened when I was at your age. I was a university student when that happened. I witnessed goons in Nairobi City clobbering a man of the cloth very badly, and the man of the cloth was wailing very badly. And I was juxtaposing that image with what happened last week in Nairobi City, where goons were unleashed on citizens, and what happened was there for everybody to see. I was sharing that with my students to teach them that there's nothing new under the sun. But the advantage is that Kenyans weathered that storm, and we have the country that you see today. And democratic waves and democratic counter waves work like that. You make some steps forward, you get a feeling that you are making steps backwards. The ultimate remedy is what we have called elsewhere eternal vigilance. you'd not give up. Because my question to young people has always been, give up, then what? Unless you want to die. Anyone who is keen to give up must follow it up quickly by committing suicide. But so long as you love life as I do and you want to live a little longer, then you must continue the struggle. You must ask, what can I, in my own small way, do to make things better? The most basic thing is what I call personal agency. That you, as an individual, should never be the agent of oppression. You, as an individual, in your conversations, in your engagement with your colleagues, in your behavior in college and out of college, must manifest these good manners that we are talking about, so that we create a culture of good manners. Then once you get a better platform, you can write, you can have discourses like the ones we are having here, you can have conversations with your family members and your friends in your groups, and eventually you will qualify to be a full-fledged lawyer. You can engage in conversations at that level, so that all in all, you are able to make a significant contribution to the betterment of your country. I think that's all I can say for now, Ruth, just to encourage you for what you have done, and you've done a phenomenal moderation of this program. And to my student and colleague, Mr. Ogada, thank you so much as usual for doing what you have done to us. We can't forget this, at least not in our lifetime. Thank you. Back to you, Program Director.
Thank you so much, Mr. Ongaya. This now concludes our webinar session today, but to the audience, remember that this is just the beginning of our Katiba at 15 series. Next week will be the same time from 2 p.m. to 4 p.m. on Wednesday. We'll be discussing the second generation of rights, and I hope I'll see each and every one of you here. So till then, I wish you all the best in your individual endeavors. Stay safe, and may God bless you all. Goodbye.